And I know that in the state's filing from November of 2023, they have the dates. So I'm not meaning to suggest that they were trying to pull anything over. I appreciate you bringing to my attention that the chase was over a year afterwards. And we kind of ran through that real fast yesterday. Just kind of was thinking in my mind without looking at all of the words. Oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
But I would just argue that he's fleeing from the armed robbery.
I know you're arguing that, but it's my ruling, so.
Thank you.
All right.
If you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat. We finna dig deep.
Now this Young Thug YSL Rico trial has definitely been full of twists and turns. But what's got a lot of people talking lately is the shocking rulings coming down from this new judge. But ask yourself, is the new judge actually protecting the state's case? Or is it something big at play? Man, before we dig deep, tap that notification bell so you'll get the drop whenever we drop over here as well. Hit that like button and definitely subscribe to the channel. Y'all know the vibes. If you don't, grab a seat. We're finna dig deep. So as day 115 kicked off, the jury is still out and the state and defense are arguing over motions. Now these motions are very critical for the defense and the state's case because this evidence can either make or break the state's case or either break the defense's defense. Now since the jury has been out, the judge has allowed several pieces of evidence from the state that a lot of people do believe are definitely prejudicial to the defense. Now these rulings have sparked a debate about whether this case is actually about just us or justice. So when we say just us, we're talking about the state protecting the state. And when we say justice, is that on the way for the defense. And today, started out with Attorney Matthews arguing his motions with more prejudicial evidence coming in from the state. Let's dig.
Instance, Your Honor, if this court allows this scant piece of evidence that has not been established that it was in fact Mr. Huey that did this conduct, we now have to look at, well, what is going to happen if this comes in? If you review this particular video, Your Honor, this police chase, you will hear in the on the radio inside the police car as they're driving on the radio, they're sending out this information. These are the things that are quoted. He has a history of running and he has all these warrants. That's in the video. Put some stop stakes in front of him. That's number one. Number two, he's armed and dangerous, known to carry a gun. That's number two. Number three, do you know where he lives at? And then they talk about his address. So these are all prejudicial items that are going to come into evidence if this court allows this particular intrinsic conduct. And that would prejudice Mr. Huey immensely here because these are things that are going to go to his character. It's going to go to propensity, and it's going to suggest that there's some type of consciousness of guilt.
Let me ask you this.
Sure.
Is it possible that if I determine that this is intrinsic, that video could be played without the audio?
I imagine they could potentially play it without the audio. But there, again, there are a number of hurdles here that I would submit that do not meet the threshold of coming in based upon those three items that are required.
Right.
So it doesn't meet 1, 2, or 3. It's over a year after the October 1, 2020 alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, even by preponderance of the evidence, which would be, I think, the standard for these evidentiary issues to come in. It was called off. There were no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster and the requirements to meet the intrinsic acts threshold. And then after that, we believe that it's prejudicial and should be kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about and tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the argument. Let's hear from the state. And I appreciate you bringing to my attention that the chase was over a year afterwards and the circumstances of that. And I know that in the state's filing from November of 2023, they have the dates. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
So it's interesting how the defense has valid arguments that are definitely mostly backed by case laws. But ask yourself this, why is the judge talking to the courts but talking directly at the state? Is the state's lack of preparation forcing the judge to actually pick a side in this case? Let's dig.
The state believes that this should be admitted as an intrinsic act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge reserved her ruling and ruled either the next day or subsequently and dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021 is when the case was indicted with additional charges and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And Your Honor, on November 30th, 2021, Investigator Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle, so they knew who he was once he entered into the vehicle. They tried to initially blue light him and pull him over. But
Was he driving? I mean, did they
He
see
was
him get
driving.
into the driver's seat?
He was driving. He was the only person in the vehicle. They attempted to blue light him and pull him over. At that point, he took off, and he, amongst other traffic offenses, went to the wrong side of traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey drove in restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport, and so they could not go any further. So they had to pull back and could not keep eyes on him. So that is why the chase was.
Okay. Well, let me ask you this. So, I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle, and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason well, two questions. Was the reason they blue lighted him because they were about to arrest him on the grand jury warrant? And do you have evidence that he knew that, such that it would arguably be intrinsic to this charged armed robbery?
Now this, again, is another perfect example how the state uses compiled evidence to try to create their points and control the narrative. Now this whole situation that they're actually describing with Marquavius Huey and running and eluding the police and all, it has nothing to do with the actual Rico case itself. So again, why is the state introducing this? For shock appeal, value, and to create the presumed thought of guilt. Let's dig.
Yes, they were going to stop him based on the grand jury warrants. As to question number 2, what I have, and these are text messages from November 8th of 2021. He says, just wait till after Christmas and the new year and turn yourself in, see what they're talking about.
All right. What? Okay. So, and the chase is November 30th. So this is several weeks before then.
Correct. And
Okay.
so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving. It appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the new year and turn yourself in, see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you. His response is, I can't miss another Christmas, man. And then he goes in, yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do. I would say to go to court, they might lock you up. He's like, yeah, but then they might not. So it appears from text messages, he was aware that the grand jury at least had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case because those text messages are from November 8th of 2021. So that's the evidence that I would have.
All right. Well, I mean, given that he says, yeah, they might lock me up, maybe they won't. I don't think that, I mean, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But I would just argue that he's fleeing from the armed robbery.
I know you're arguing that, but that's my ruling. So
Thank you.
all right.
Yeah.
Come
Sure.
on now,
Can I
sir.
just bring up
Come
another
on.
concern on this subject? The concerns aren't limited to Bruton. I still we're talking about playing a tape where Mr. Kendrick says that other people are saying He's not saying anything that he knows. He's not telling on anyone, but he's saying other people are saying that our crew and Shannon and Woody, and they're talking about taking Shannon's name out of it, which of course I'm in favor of, but I'm not even.
Yeah, no, I agree. That's a little weird that the state's evidence would be, well, I mean, here's what the rumor on the street is.
Right.
So I bet Ms. Relev's going to say we're not intending to elicit that.
Now, the state's case is being built off conspiracy and co-conspirator statements. But ask yourself, with the state sitting here presenting this information and evidence in front of the judge with no jury, does this case look like they're prepared? Does the state look like they're prepared, or do they actually look like they're just grabbing whatever they can, since it's a motion hearing, to see what's going to be allowed by the judge? Now, it's interesting that the judge made her ruling with Hilton based off that intrinsic evidence. And ask yourself, again, what did that have to do with the Rico? Was that just more compiled evidence being utilized for the state to control the narrative? And interesting how the judge called it. Now, she did make this play in favor of the defense, but pay attention, because this way it gets deep.
Exactly, Judge. The point is not, and we can tailor the questioning and the presentation of evidence to, not include.
Okay, well, I mean, I suspect the reason they're asking that now is because when we just went over that example, you thought that the only, and you may have just been saying the only part that I believe is brutal is this part where somebody is specifically mentioned, and that's fair. But if you don't intend to use any of that portion of the tape anyway, or get a question and answer that would elicit that information, then it would be helpful if you would say that, because there's no point in us, spending time on something that the state doesn't intend to use anyway.
Now, you know what's sad? Is that even the judge is saying, stop introducing evidence that you don't plan on using. Stop doing it. Like, shit, use something that we ain't seen. Use something that's critical to the case. Use something to give you some substance or something. Like, just stop putting stuff up here just to say that it's evidence. Just because it's in your possession does not make it evidence. Jesus. Like, goddamn. Let's dig. Look at Weinstein looking up. He tired. The defense is tired of her babbling, bro. Come on, Ms. Love. Study it out.
Let me ask you this. Do you think that it's relevant for the jury to hear that
Look at his face.
Mr. Kendrick said, well, here's what the story on the street is right now?
No, that part I don't. I don't think that part about, the people on the street think XYZ is relevant. The relevant part is his acknowledgement that our crew was beefing with them. Okay. There was a us and a them that was in conflict.
Okay, so then the only part of that then that you might elicit is that he acknowledged that at the time this all occurred, his crew was beefing with the other crew.
Yes.
Right.
Okay. The pictures, Judge, are just as he's talking, he would.
All right, so who are I see we've got
Defendant Williams,
Mr. Williams, Rich Homie Kwan.
Bermian.
Are there pictures already in evidence of those three people?
Yes.
Then use the pictures already in evidence. How about the bottom two? Who are they?
Donovan Thomas is on the far right side.
Is there a picture of him already in evidence?
There is a picture of him in evidence.
All right, use that. What's the middle fifth one?
And this is Defendant Williams. Pre the dispute, the war.
Okay. Is there a picture similar to that if he needs to identify people or a group of people he could use?
Yes. Numerous.
Hold on one second. Have videos of the groups of
all right, so you could do a still from a video. Okay. All right, how about slide 4?
Your Honor, and our position regarding the displaying of these pictures is that they're demonstrative as he's talking about them. Of course, they've seen Mr. Copeland for whatever, so they sort of know who he is. They haven't seen as many pictures, just face shots of Mr. Watts. So they're not, we would just put forth that there's...
Is there a picture of Mr. Watts in evidence?
Yes,
but they're demonstrative.
Looks kind of similar to this.
So the reason that we would ask that the PowerPoint photos be allowed to be kept in is they're demonstrative. These are clear face shots of who they are talking about. There's nothing that is inherently or substantially more prejudicial due to the cumulative nature of these photographs that would cause either defendant to be in danger of being convicted of something or on something other than proof of the crimes we have listed in the indictment.
Are they going to, for some reason, be talking about Mr. Copeland and Mr. Watts together? That they're like,
Yes.
it's going to be crucial for the jury to see here's Copeland and here's Watts.
Not crucial. But he will be talking about a specific interaction, specific.
Okay, well, he can talk about that without this. And if you need to like have the jury reminded, oh, this is what Mr. Watts looks like or something, just use something already in evidence. All right, what's this picture of some fence?
The gambling house that.
Do we have pictures already in evidence of that?
No.
Okay, then this one's fine. Slide 6 with the stack of money and obscene gestures.
Well, that's Mr. Copeland, and it was that stack of money and that flashing of it at a club that led to the conflict between him and Mr. Watts. So,
Okay.
Video of him doing exactly the same thing.
we don't have that.
Yes, we do. We had it in video and
All right, well, don't talk over each other. Do you know what exhibit number that is?
Your Honor, we initially entered the video in June. However, that was after 3 o'clock. And so we did not enter it again this time around. So I do not believe the video was in evidence. I'll double check. I believe that was after 3 o'clock.
Actually, good point there, because we do need to make sure when we're finally reviewing what evidence is in and out, that we make sure that everything that was entered in that little period of time is unentered, if you will. So, okay, this one's fine. He can use this one.
Now, in my personal opinion, here is where the case started getting interesting today. Now, the judge came out hot, actually in favor of the defense, saying that, yes, the state's evidence that they are introducing is definitely irrelevant to the case and the Rico altogether. But then, it's like she had to change her heart where she just started allowing still images of evidence, telling the state, advising the state to use this, use that. Now, at first, I was like, well, okay, she's just simplifying the case for him. But then I started thinking, is the judge working with the state? Because it seems like she's actually telling them what to use, assisting them with their evidence on how they can use it, and definitely limiting them to the evidence on what they can use. So this is starting to get interesting because the judge herself seems like she's more starting to help the state against the defense. But then she makes a ruling which rules in favor of the defense. So is the judge actually being fair? Was she's actually creating justice? Or is she working for just us, meaning the state, protecting the state? Let's dig.
Can I inquire as to exactly what the relevance would be of showing a picture of Mr. Copeland holding money and flashing the bird?
Well, I mean, they said that was what had started a beef between him and Watts.
The flashing of the large sums of money.
Not the flipping the bird.
I mean,
Yes, no?
the flipping the bird, I mean, it wouldn't have, our argument is that it's relevant because it shows Mr. Copeland with that huge stack of money that we're talking about, and it makes.
Is this the night of?
It's.
Or is this just.
You say the night of, not
the
John
night,
and Thomas.
No, the night that the beef starts between he and Watts.
No, Your Honor, it is not.
It's just an example of him with a bunch of money.
Holding money.
An exemplar. Good word.
I think it's January the 8th. The 6th, January the 6th. So it was the night, it preceded it. That's the night that the fight started that led to the arrest of, I think, Mr. Kendrick and Mr. Arnold the first time when Bloody James punched out.
But this is a picture from the night that, it all got shot up or something?
I'll confirm, but that's what my understanding that is January the 6th.
I don't know it's January 6th. What is that?
I don't know. I don't know. Maybe they know what he was wearing to the club
The
that night.
detective that gave it to us, so.
My recollection is that he had different clothes on at night when he was flashing the money than he does in this particular picture. I do not believe.
So do you have any kind of picture from that? I mean, if you can confirm it was that night, that's fine. Otherwise, it's just an example of, hey,
well, not just
here's what we mean about flashing money.
No, the large amounts of money.
Right.
I think during the course of the interviews that the jury has heard, you hear them talking about a very, very large sum of money.
Right.
And, one might argue or wonder, what kind of money, how much money did he have access to that kind of money? Him having a stack of money like this. I mean, it could have all been ones, but even ones would have been a lot. I mean, I'm just saying. So the relevance bar is, of course, as the court knows, is a low bar. And the fact that he's sitting there with that.
Okay. Well, he also is flashing the bird, though, or flipping the bird. So that's a little bit offensive, I'm sure, to some of the jurors. So maybe there's a. Why don't you find out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money, okay? So we'll revisit that when we've got some more info.
Yes, Your Honor.
From the defense at the point in time, if you seek to tender that, but we'll just deal with that at trial. But don't be surprised, because I certainly think if I were the defense attorney, I might have an objection to it.
I think they wanted this part in because this is from
well,
the
we'll
other
see.
side. This is
We'll
the
see
guns
what the
from
strategy is.
from the other side.
We'll see.
Okay.
Okay. That's what makes trials interesting.
So 18 is out.
So, no.
I'm sorry. Okay, I apologize. Mr. Atkins is reminding me that you're talking about gang expert reports and things like that.
Yeah.
And yes, we don't have anything extra. We will go back again because I've gone over and asked homicide. I've asked gang. I've physically gone over to the gang unit, physically pull out boxes of stuff. I will continue to inquire.
All right. Well, I don't know that, the best use of your time is to pull in boxes and look through them. That ought to be what the police are doing, but you need to direct them to do that.
Yeah.
And so with regard to the gang experts, did y'all go back and say to somebody over at APD and in gangs, hey, we need anything there is, even if these detectives are now retired?
Well, we had done that before the court ordered us to.
I know, but then I ordered you to, so did you do it again?
Okay, so
Because I ordered you to.
we have not inquired a second time, and I apologize to the court. We're going to do it again. I will do it.
I pretty
personally.
clearly told you to do it again.
That's what he's reminding me.
Yeah. Well,
So-
Mr. Atkins, you could have done it.
Yes, Your Honor. I'll go make a phone call now.
Okay. From the defense at the point in time, if you seek to tender that, but we'll just deal with that at trial. But don't be surprised, because I certainly think if I were the defense attorney, I might have an objection to it.
I think they wanted this part in because this is from
well,
the
we'll
other
see.
side. This is
We'll
the
see what
guns
the
from
strategy is.
from the other side.
We'll see.
Okay.
Okay. That's what makes trials interesting.
18 is out.
So again, I ask, is this case about just us or just this? Now, on the flip side, there are arguments that the rulings coming down from the judge are about something much simpler, simply winning the case. But ask yourself, is the judge actually allowing in evidence that could actually sway the jury in favor of the state? Or is the judge actually making sure that the state has the upper hand in securing a conviction? Now, we did see some rulings where she made the state actually remove some of the verbiage that was attached to some of the documents of evidence that they were going to display to the jury with this trial. But ask yourself this, is it all about shock appeal? And have we seen it all before? Does the state have anything new that they can introduce to make us feel like Rico actually existed? Or are they just basing the whole narrative off shock appeal and conspiracy? So after sitting and watching this, would you actually say that this judge is actually doing the same thing Judge G was doing, just in a more professional manner, assisting the state? Or is she actually creating an opportunity for fairness down the line in case an appeal comes up after a conviction? Are the judge's rulings actually protecting the state, as in just us? Or are they actually tilting the scales in favor of the defense for justice? Are these rulings just part of the judicial process, ensuring that every piece of evidence gets its day in court? And most importantly, how will the judge's decision impact the final verdict of this case? Definitely want to hear from all of you in the comments. Is the new judge as biased as the previous judge? Is justice on the way? Or is this just us? Are we literally watching the state protect the state? Man, y'all jump in the comments, let me know. Drop y'all thoughts in the comment below, and let's get this conversation going. Man, will YSL ever actually get a free trial? Or are they just going through process that's not due? Man, it's your boy Jay, and remember, the life you save might be your very own. Until next time, gone.
YSL is not a game. So you can't, y'all keep trying to taste it to things that go on.